How's the Rav today?
Good, good. How's everybody doing today?
Confused.
Confused about what? About Corona? We're all confused about Corona.
We have no about the election. No idea.
I don't know. The latest I heard is that maybe Biden is going to win.
I don't know what Hashem's got planned for us. I'll tell you everything.
Right.
It's just, oh,
Let me say a few words of introduction. About today's class. In Corona, there are many different areas and many different shilas that came up during this period and continue to come up. And in general, I think you could say that it's kind of like asking a Rav a question, you get an answer. Sometimes it's a little bit more complicated. You want to get an answer in writing, you want to get a letter. And most of Corona, I would say, are shilas that really are examples of shilas that are typical of other shilas, even without Corona, just that there's a very intense and sometimes very unique situations that we've discussed that came up during this period of time. But what I want to discuss with you today is something that goes way, way beyond just asking a rabbi a question and trying to get an answer. We are now about to embark upon an investigation of an area of halacha that requires so much complicated knowledge that it, in a sense, it stupefies even the Batei Dinim. Imagine you're sitting in front of a Beis Din that's made up of 3 judges and the questions are so complicated. These are the monetary questions that came up during this epidemic and continue to plague us in terms of situations in which monies were promised, services were promised. Because of this epidemic, it was impossible to supply those services. There are situations in which a person agreed to pay in order to rent a certain place, and now he cannot rent that place during this period of time. He cannot benefit from the object or the house or perhaps the ulam that was rented. Now, as I said before, these questions come up in front of Batei Dinim, in front of the courts of Israel. And just to give you an idea, I happen to know this from the inside, that in order to prepare and be certified to sit on a Beis Din for what we call Dinei Mamonos, for monetary law, the average period of time for study is approximately 10 years. Now, you may say to me, well, if I wanted to become a surgeon, I would have to study for more than 10 years, right? I have to go for 4 years to undergraduate school, have to go for 4 years to medical school, that's already 8 years, then I have to do 3 years of study in my particular area, let's say surgery, as we said, and become an expert in that field. That's already 11 years. Then I have to do stage, which means I have to learn how to do, you have to be apprenticed, and that takes another 2 years. So you might ask me, what's the big deal about studying 10 years to be a judge in a Jewish court? But I have to tell you, it's much, much more than 10 years. I can get into medical school if I have the grades and so forth at the age of 20, 21, 22, in some countries, even at the young age of 18. But in the case of studying for Dayanut, the average age of the person who enters into the program is about 25, which means that he's put in already 25 years of learning before he even starts to study for Dayanut. Why am I telling you all this? Because the topic that I've chosen today has perhaps more issues and more nuances and more dimensions, dafka because of Corona, than any of the areas that we've touched until now. So if I want to ask you whether or not I can daven on my porch and listen to a minyan on the next porch, I'm not trying to belittle that issue, but that's something that you would ask what we call a shelas chacham, a shelas rav. If I, for example, one of the issues that we've covered in the past is whether or not I can make a bracha on food, on smell. You know, if I have Corona and I can't smell, again, that's a shelas rav. You know, we've discussed questions of isa v'heter, of mitzvahs tefillah, kriyas haTorah shilas that come up all the time during Corona. But these are not questions that have to be brought in front of a beis din. It's basically my own issue. I want to know how I can fulfill my obligation vis-a-vis tefillah or kriyas haTorah. What are my obligations in a case of tefillas kalim, in a case of tefillah b'mikvah? When it comes to dini mamanos, there are two parties involved. There's a tovea and a nitva. The tovea we call the plaintiff, and the nitva we call the defendant. And this is not something that you can just ask a rav. You know, what's your opinion? Do I have to pay him? Do I not have to pay him? Can I force him to pay him? Can I not force him to pay him? This is something that really has to go in front of a beis din. And a myriad of questions during the last few months, it's almost now probably 8-9 months since the pandemic broke out, have been brought up in front of many, many different batei dinim. I have in front of me a sefer called Heviani Chadarav, which I've mentioned to you in the past. And he has an entire section on Choshen Mishpat, on the monetary laws and the issues that have been faced by batei dinim over this past period of time during the Magefa, during the epidemic. And most of what you'll see on these pages are footnotes. You'll have sometimes just a few lines on top and a whole page of footnotes, because in the footnotes, he is quoting not only early sources from the Gemara and from the Rishonim and the Achronim, he's quoting actual decisions that were issued by batei dinim, by various courts during this period of time. And all this by introduction, because I want you to realize up front that we are stepping into, if we want to study and investigate the laws of this epidemic from the perspective of dini mamanos, we're stepping into what we call mayim she'ein lehem sof. I mean, it's like a bottomless pit. It's incredibly complicated. Who can say that they studied for 10 years at the age of 25 and they can sit on a beis din? Certainly I can't say that. Maybe you could say that. We're talking about the most complicated issues in monetary law, some of which could entail major sums of money. And even if it's not major sums of money, then for the people who are involved, it could be their entire livelihood is at stake. And if they weren't able to produce the goods, does that mean they have no right to get any payment whatsoever? From the flip side perspective, why do I have to pay for services that weren't rendered? I rented a house. I can't use the house. There's no way I can get into the house. It's in an area, it's in a zone which has been prohibited by the authorities. What about a case where I rented something, but I don't want to pay because I'm in bidud, I can't get out of the 4 cubits that I'm locked up in? So I don't presume, and I don't try to tell you up front that we're going to come up with the answers to these questions. what we want to do in the time that we have is to introduce concepts, terminology, basic Gemaras or Piskei halacha from the Rishonim, the Achronim, and guidelines. Now, one thing I could tell you up front, the most important principle in Jewish monetary law, and it's to some extent, I think, other legal systems, lahavdil, have imitated Jewish law, but it all started in Jewish law, and that is hamotzi mechaver levarayah. What that means is that if you are suing me for monies, the burden of proof is on you. I don't have to pay you if I deny your claim until you have ample proof to substantiate your claim. I, in this case, as the defendant, am called muhsar. Now, again, I'm going to use that term over and over again today, so you might as well get it down pat now. Muhsar. Muhsar means I'm in possession. You want to take the money out of my pocket, out of my bank account, I'm in possession. In American law, there used to be a phrase, I don't know if they still use it, possession is 9/10 of the law. Now, the reason why this concept of being a muhsar is so critical in all the issues that came up in all the different courts here in the Jewish courts during the course of this pandemic is because there are so many different opinions. And it's almost, if I would be a little bit maybe cynical about it, the joke would be, anytime you ask a question in Dini Mominus, the answer is it's a machlokas. It's always going to be a machlokas. And if it's always going to be a machlokas, and we're going to have two opinions, then who is the muhsar? And therefore, in the case of a muhsar, I have a right to say to you, look, you're right that this opinion would have it that I have to pay you. This opinion would have it that I don't have to pay you. And therefore, since I'm a muhsar, the burden of proof is on you. I don't have to pay you. That's where muhsakas plays such a major role here throughout everything we're going to discuss. Our goal may be to find areas where we have a general consensus or the halacha is crystal clear. Are there any rules or regulations that certainly tell me either I'm chayav to pay you or I don't have to pay you, I'm patur, so that I don't have to get into the issue of safek and muhsak. There's even one principle in Dini Mamanos that the muhsak is allowed to say kimli. Now, that's an important concept. Let's make a note of it. Kimli means that if you're suing me for damages or for monies, and I'm the defendant and I'm the muhsar, then I have a right to say that I know the halacha is like this opinion. Even though, again, I'm not a scholar, I certainly don't know anything. But if that opinion will protect my muhzakus and exempt me from payment, then I'm a muhsak and I have a right to say, well, the halacha is like him. And unless there's a clear-cut halacha and a final decision which is completely unanimous, which I doubt if we can find in the world of Dini Mominus, then I always have the right to say, Kimli, I know that the halacha is that I don't have to pay you. Even though you have plenty of leg, you have a good leg to stand on because there are many poskim who say I do have to pay. So our goal for today, as I said at the outset, is to try to find the basic guidelines, the terminology, the fundamental concepts and sources that will give us a flavor of how this ongoing story is developing. It still is developing as we speak. More issues are being addressed by Bati Dinim. There are more lawsuits going on in which there is a plaintiff who claims that he has to be paid. And there is a defendant who claims I don't have to pay. If you have the text, which David was kind enough to circulate, and then the question is if you could read the text, because I just took the pictures and sent it out on WhatsApp. I'm not a professional. I can't find the exact lighting that I need. So we begin our discussion on the first page. I tried to give the pages numbers in sequence because it doesn't always come out in the picture that I took that you'll see on the top right or the top left, the page number, but here in the book, it's actually page Ayin Ches, and it's page 1. I'm sorry. Let me correct myself. It's page Ayin Beis, and it's the first page that you have, and it's called Choshen Mishpat. Now, you'll see that most of what's on this page has to do with what's called a check. I sign a check and I hand it over to you. The check is not worth the paper it's written on, but the check might be worth billions of dollars because now you can take the check and go into a bank and you can take out of my bank account $1 million. Who's considered muhsak in this case? I, for example, ordered some merchandise and I gave you a check. In the meantime, this epidemic breaks out and you're not able to supply the goods, or alternatively, I'm not able to enjoy those goods. And in either one of those two scenarios, the deal should be called off. But on the other hand, there may be poskim who say, well, look, you did whatever you could. You provided whatever services or whatever goods that you possibly could. Beyond that, it was out of your control. And therefore, you have rights to get paid. If not paid the entire sum, at least part of the sum. You may have already taken money out of your bank account in order to supply me with the goods. Like, take, for example, one of the cases that we're going to deal with is catering. So I ordered a caterer to deliver the food for, let's say, a convention or some sort of celebration, a simcha, a chasana. And as a result of this pandemic, I have to cancel the order. On the other hand, you already spent money preparing the food. You're the caterer. You already ordered the food. The food is going to spoil. So then maybe poskim will say that in this case, you have rights to demand that I pay you to offset your losses and your damages because it was out of your control. So that there may be different opinions in halacha, and I gave you a check up front. You're holding on to my check. Does that make you muhsak? Do we view the check as what's called a hora'ah? Hora'ah means it is a mandate, so to speak, that I give to the bank that they will take the money out of my account to give it to you. The check itself is not what we call mammon. It's not something that in and of itself inherently has any value that you're holding on to the mammon. And now the burden of proof is on me to get my check back. No, the check means I gave a license. I gave the green light to the bank to pay you. I have the ability to cancel the check. So what you'll see here on page 1 of the pages that I sent you is a major machlokes, an issue that divides the contemporary poskim as to whether or not a check makes you into a muhsak. If I gave you a check for services, for goods, etc., are you considered the muhsak? You're holding on to my money. And Rav Shlomo Zalman Auerbach got involved in this question back many, many decades ago with regard to Shemitah. How so? The law is that Shmitas Ksofim, once every 7 years, cancels debts. So if I owe you money and you did not collect that money until Shemitah came around, I don't pay you. And that's called Shmot, or Shemitah Mishametes. It breaks up the chov and makes it impossible for the lender to collect from the borrower. What happens if I, as the borrower, gave you already something? The classic case is what's called a mashkot. I gave you collateral. So I gave you a diamond ring in lieu of the $1 million that I owe you. In such a case, Shemitah is not meshamet. Why? Because the collateral, the mashkon, is considered as if I already paid you up. I have rights to redeem it and give you cash and currency in order to get back my collateral. But in the meantime, it's as if I paid you up. And therefore, you can take this diamond ring in an event that I default on the loan, and you could cash it in and you get your money. So that mashkon is virtually a payment of a debt, and therefore Shemitah has no power over this debt because the debt is already paid. What happens if I borrowed money from you, but I gave you a check, and I say to you, do me a favor, Reuven, hold on to this check, and when I have the funds to pay you back the debt that I owe you, give me back the check or rip up the check. Is that the same as a mashkon? And one school of thought, which we will right now, for the time being, we will identify that school of thought as Rav Shalom Elyashiv. He paskins that a check is not money, but rather hora. It's just a notification and a license to the banks to allow you to redeem that money and get it from my account. Therefore, it's not an object like a mashkon. It's not a payment in any sense. Again, it gives you, who are holding on to the check, the rights to collect the money. But right now, the money is not in your account. You're not holding on to any object of value. And therefore, according to Rav Elyashiv, in that case, Shemitah will be Meshameh T'chov. It's a regular debt without any payment, without any collateral. No mashkon was delivered. The check is not considered mammon, and therefore, by receiving the check, you have not received payment, and therefore Shemitah is Meshameh. His mechutan, because they married off their children to each other, Rav Shlomo Zalman Auerbach asking, no, the check is considered like a mashkon. It's like a payment of some sort, it's a form of payment, and therefore Shemitah is not Meshameh T'chov.
Do they make a difference between a post-dated check and a?
Excellent question. First, before I get to your question, there's a much more fundamental distinction or categorization of two types of checks in halacha. Now, you're going to have to help me here with the English, because, when you live in Israel after so many years, you get used to the Hebrew terminology. You don't even remember the original English terminology. So if you can help me, there's a check here in Israel which is called lamutav bilvad, which means that I put two lines I put two, we'll call it vertical lines, a little bit on an angle, but over that line where it says pay to, right? So I'm writing you out a check. I put two lines, and I inscribe on the top of the check la mutav bilvad, which means that no one else has rights to redeem this check except for you. On the other extreme, there's something called an open check, check patuach, which means a commitment on my part when I sign such a check, and anyone who has possession of the check can redeem the check and collect the money from my bank account. That means, legally, if I drop that check and you happen to be the lucky man to find it, you can actually cash the check in the bank.
That's a question.
I didn't hear the question. Yeah, please.
I have a question. My question is, so let's say it's this open check business, right? So even
What's
though
it
you're
called in English? I
don't think there's any
okay.
any equivalent, but anyway, I find this rather odd, because let's say I write out a check for Mr. Smith and Mr. Jones tries to cash it, and the bank will say, sure, no problem, because it's open.
That's basic.
It can't ever happen.
If it's, again, lemutav bilvad is a legal concept here in Israel. I can't tell you exactly what it's called in your part of the globe, but lemutav bilvad is a legal concept, which means that only the mutav, only the person whose name is on the check has rights to check. He can't even pass it on to a third party.
See here, okay, here in Canada,
that's what I'm telling you. I just want you to know some of the the terminology here that's very important in the postscript. So if you're looking, for example, on page 1, going on to page 2, in the footnote, he says, Das Hagon Rav Yosef Shalom El Yashiv Zichrono Livracha She'ein Shek Nidon Elika Hora LeBank. So this is 4 lines up before the end of page 1. It's a Hora'ah LeBank. And again, it just notifies the bank that you have given permission to cash this check. V'chein Kosav B'Shevet Halevi. This is Rav Vozno, who died not long ago. These are some of the big guns here in Israel. However, earlier in this paragraph, he writes, Das Hagon Rav Shlomo Zalman Auerbach Zatzal, Gabi Shmitas Ksofim, Shechekim Shenitan Laviram Nechshavim Kechefetz O Kemashka. They have the same status as an object that has value to it. Right? I give you a diamond ring or a vase, a beautiful vase. You know, it's an antique vase made of who knows what. It's worth tens of thousands of dollars in auction. And I don't have to, and I shouldn't say I, because you have to be very careful. The Baal Chov, the person, we call him the Malva, if you'd like, the lender, doesn't have to be Mishamit the Chov, because basically he's got the money in his pocket. Now, I understand if I give you a diamond ring, you have the money in your pocket. I've virtually paid you up, just that I left myself a little bit of rights to redeem the object. But in the case of a check, that's not a chayfetz, that's not a mashkon, that has no inherent value. Says Rav Shlomo Zalman, a check has inherent value. It's nechshav kechayfetz or kemashkon. And therefore, the chov is now protected on behalf of the lender. The Baal Chov now is not subject to the laws of Shemitah. Now, what ensues here on page Ayin Gimel, which is the second page that you have, is a discussion as to whether or not Rav Shlomo Zalman would therefore be committed to the following position, that whenever I give you a check, you are considered a muchzak. Some want to say that when Rav Shlomo Zalman gave this issued this ruling, he was talking about Shemitah. And this doesn't go beyond the scope of Shemitah. In the laws of Shemitah, the question is, do I, as the lender, have to come to you and extract the money from you? If I do, then the Torah says, lo yigos, that comes the Shemitah year, and I'm not allowed to come and press you to pay me back. If, on the other hand, I don't have to come and press you because I'm holding on to a mashkon, I can, tell you to take a slow boat to China, and I still have what I need because you gave me a diamond ring. Then there's no lo yigos. Comes along Rav Zalman, Rav Shlomo Zalman, and he extends this even to a check. Even in the case of a check, Rav Shlomo Zalman understands that that check is legally binding, and therefore, if the malva, if the lender is holding on to that check, he doesn't have to be running around the love. He doesn't have to knock on his door, little egos, and force him or demand of him that he pay up the debt. And therefore, there's no Shemitah in such a case. But Rav Shlomo Zalman did not go as far as to say that in any suffix mammon, in any time to be a doubt as to whether he has to pay you, doesn't have to pay because you're holding on to a check, that makes you into a muchzak. And whether or not this may surprise you or not, I don't know, but the preponderant majority of poskim in contemporary world assume that a check is not considered muchzak. It doesn't make you into a muchzak. Whether it's because at any moment the person who signed the check can cancel the check, whether it's because, as Rav Elyashiv would have it, because a check is nothing more than a hora. What did he call it again? Hora lebank. I'm just notifying the bank that I'm okaying his collection of the money, but it's nothing of substance. It's not worth anything. Or perhaps for another reason. And that you'll see here on page Ayin Gimel on the top. Kartis Ashroy. We're talking about credit cards. Now what happens is, I don't actually give you my credit card from hand to hand like I would in the case of a check. But I do give you the numbers of the credit card. I may even give you the code of the credit card. And he says that there's something, again, you'll have to help me with the English here in your part of the world. In this part of the world, it's called Hora'at Keva, which means that I can sign a document that gives you rights to collect a certain sum of money on a monthly basis. And according to, again, as far as I know, all the poskim, Horas Keva does not make you into a muksa. And for that matter, even a credit card payment does not make you into a muksa. A credit card gives you the rights to go to the credit company, which is more or less like a bank, and collect those funds, but you don't have the funds in the bag. And therefore, in so many of the issues that came up during Corona, where the Toveh says to the Nitba, the halacha is like me, because I have your check, I have your credit card information, and I'm the muksa. I don't have to come to you to collect this debt that you owe me because you ordered my services, or you hired me, or you paid rental monies. You gave me a credit card. The rest is history. The answer is no. He's not a muksa. And again, this is one of the areas of Choshen Mishpat, which again, don't rely on me, obviously, but I'm just telling you the impression I have. One of the very few spots in this whole complicated situation where the poskim agree. As far as the check is concerned, that's an outstanding issue, and you're going to have poskim lakan. Once again, if I had to tell you where I sense that the majority of the poskim rule, I would say that they would apply the principle of Rav Shlomo Zalman that a check makes you into a muksak. But again, that's really oversimplifying it. Many will hold like Rav Elyashiv, and a check does not make you into a muksak. But a check is something that's very easily collectible. And by the way, if you want to cancel a check, at least in this country, there are many legal implications of such a thing. It's not a simple matter to cancel a check. But with regard to credit card, everybody agrees that a credit card is something, let's call it digital. It's something that exists in the virtual universe. And it's really just a legal device which gives you rights to collect monies. But it doesn't mean that the money is in your pocket. You are not considered a muksar, neither in the case of credit cards, nor in the case of Horas Keva. Omnami writes, Tashlum shecholek mitchila letashlumin bekartis hashrai nechshav letashlim mirosh. Now here we get into another concept, which is called tashlum mirosh, meaning prepayment or down payment. Again, each one of these terms is slightly different, but for our purposes, sometimes I demand from you, if I'm providing services or goods, that you give me a payment up front. I don't want to have to run around and wake you up in the middle of the night to force you to pay me. That's too much of a headache. I want to be prepaid. That's called in modern Hebrew, tashlum mirash. I feel like I'm already a Rebbe in Orchaim, in Almore Avenue there, because I'm teaching you the Hebrew terminology here. That Orchaim is into the Hebrew. But I have to tell you that the most religious poskim with buds and payas are using these terminologies today here in Israel. It's not something that, you have to wear kippah sruga to talk about tashlum mirash. These are basic concepts because these are part of the very fabric of the monetary system. Now, a law was passed in Israel recently that a check that's open is only cashable up to 10,000 shekel. So if there's a check that's signed for 10,000 shekel or more, and there's no name, it's not written limutav, it's valueless. You would have to go to a court, a secular court here in Israel, in order to validate such a check. No question about it, that in that case, we have what's called another terminology, Dina de Malchusa Dina, which means that Dine Momenos is guided by two different systems in halacha. One is the pure halachic system, and the other is called Dina de Malchusa. Now, who cares about Dina de Malchusa? Why should I care about the law of the land when we have the beautiful Torah with its own halacha, its own laws? But the answer is that when it comes to Dine Momenos, the halacha recognizes the nature of the agreement. What did you agree to pay, and what services did I agree to provide? That agreement, with all its commitment on both sides, is what determines what we call in halacha das makna das kona, and that das is going to be determined by the law of the land. So I can't pull out a check that's invalid and say, well, let's recognize the check, because if the law of the land is that that check is invalid, it is invalid. So that when we deal with Choshen Mishpat, whether it's here or anywhere on the face of the globe, we have to deal with it on two different levels, and then we can integrate the two. We have to know what the law of the land is, and that's a determining factor. We also have to know what the halacha is. Now he writes here, check shenitan lemutav bilvad, shem hamakabel nirsham al kabav. This is line 3 here on page, in the footnote on page Ayin Gimel. Eino eliko ra lebank, the ein laduno klal kishtarcho. When I read this, I said to myself, Ifcha mistafa. This is counterintuitive. If I was trying to determine which check is more binding and gives the holder of the check a din, a status of a muchzak, I would have said, if it's written lemutav bilvad, Ruvain is holding on to the check and his name is on the check. But it works just the opposite. Once I take a check and I write lemutav bilvad and it's only for Ruvain and he's the only one who can cash it, and all the poskim agree that such a check is nothing more than a hora lebank. I am telling the bank that when Ruvain comes into the bank with this check, please, you have my license, go ahead and remove that sum of money from my bank account. So here's where Reb Shlomo Zalman agrees with his mechutin, with Rav Elyashiv, that a check does not make you into a muchzak. It's counterintuitive. You would have said that if my name is on the check, ich bin the balabas, I'm certainly muchzak. And now we're saying just the opposite. You see how the halacha works with very subtle categories and definitions. If my name is written on the check is valueless. Who in the world can use that check? Nobody, except for me. That means it's not mammon. It's not an object of value. An object of value has to have objective value. So dafkin, in the case of an open check, which means that anyone who grabs onto the check and is lucky to possess it, even if he finds it in the street, he can go into a bank and cash the check. Here's where we have a great debate between Reb Shlomo Zalman and Rav Elyashiv. Is that considered objective mammon? Because anyone on the face of the earth can get a hold of this check and convert it into cash. But if it's lemutav bilvad, then we define the check as hora lebank, and it's not money. Okay. Now, in cases where the muchzak is really a muchzak, and he claims based on, some poskim, some bezdin somewhere on the face of the earth that he doesn't have to pay. Now enter stage another concept in Jewish Choshen Mishpat called tfisa. Tfisa, if I had to give it a phrase or an idiomatic expression, would be take the law into your own hands. And what happens now? The Toveh, the plaintiff, has ample proof supporting his claim that so-and-so, the defendant, has to pay him. The defendant says, well, I'm muksok, and you know what? There's an asivis or a machna Ephraim somewhere in Choshen Mishpat that would protect my position. Does the plaintiff have no recourse? There's something called tfisa. Now, how and when tfisa works is beyond the purview of our discussion today. It's just important that you know that in a case where muhsak is going to win simply because he's muhsak, there's no logical proof to support his position. On the contrary, there may be more evidence that supports the position of the plaintiff, but what can we do? He's a muhsak, and he says, Kimli, and I know that the halacha is like this, and therefore I'm the defendant, I'm muhsak, I don't want to pay you. There is a recourse. The plaintiff is not totally out in the rain or in the snow, whatever it is, because he has a possibility of tefisa. When and how, that's beyond our discussion. Now, here I want to point out.
I'm sorry.
What is page 3?
I'm sorry. What is tefisa?
Tefisa, in the literal sense, means I take the law into my own hands and I put my hand into your pocket, Joe. I know that you owe me 100. You're not willing to pay me. Why? Because you're the muhsak. But I have enough proof that you really have to pay me. But what can I do? You're the muhsak, and you claim, well, you have a certain posek, some Rabbi Pachuch out in Turkey, and he says that you don't have to pay him. You don't have to pay me. So in such a case, if I put my hand into your pocket and I take the law into my own hands because I know that you owe me that money, I become the muhsak. Now the burden of proof is on you to force me to give you back the money. Just mentioning. Now, here's another question that comes up with regard to dini mamonos. As we said, since dini mamonos involves two people with claims and counterclaims, it cannot be ruled in halacha by a rav. It's not like I go to my local rabbi and ask him, well, can I use this kli? I can't go to the mikveh. It's my gefa. I can't use the mikveh. Tell me whether I can use the kli or not. I go to my local rabbi, my local Orthodox rabbi, and he gives me the final psak. Not so in dini mamonos. In dini mamonos, we need what's called a bezdin. And the problem is that when this epidemic reached its pinnacle, again, I don't know what's going on in your part of the world, it was impossible to gather together a bezdin. And the halach of a bezdin is called Bimosav Tlosa Havino. We were sitting 3 people together, and we formed a court. I can't get 3 rabbis together during this Magefa. How am I going to get a court to issue a valid binding decision in halacha when I can't even get 3 dayanim together to sit on a court? So the answer is that b'makom hatzorech, that since we're going through a very unusual set of circumstances, we're going to fall back on something that normally would not be accepted and recognized as a bezdin because we don't have 3 dayanim together. And the trailblazer here is the Shulchan Aruch in what's called Turgamon. Let me explain. The law is that if I am subpoenaed to show up in a bezdin, or if I sue you to show up in a bezdin, each one of the claimants has to put forth his claim directly into the ears of the judges. No miturgamon. We will not allow someone in between. For example, let's say I only speak Russian and the dayanim don't understand a word of Russian. No Panamaya, right? Whatever it's called. Can I set up a translator? And the law is that there's no such thing as translators. Actually, the the Dayanim have to learn 70 languages. However, the Shulchan Aruch paskins that b'eis hatzorech, if there's a pressing need, then yesh lishma et hatainos shel habali din al yedei meturgamo. The Dayanim could hear the arguments and the claims based on a translator. And the super commentary on the Shulchan Aruch called the Piskei Tshuva, or if you're Hungarian, the Piskei Tshiva, because he was Hungarian, he says that that if it's impossible, we don't have anyone who can sit on a Beis Din who knows Swahilian, so we'll use a Miturgum. Not only that, the Shulchan Aruch goes a step further. I'm sorry, not the Shulchan Aruch, the Aruch HaShulchan. That's already a contemporary almost. I mean, 19th century, 20th century, I should say, right? The Aruch HaShulchan paskins that if you can't show up in a Beis Din personally, you can send a representative to put forth your claim, your lawsuit, in your stead. Why? Because again, it's considered b'makom hatzorech. The poskim say that in our time, where you can't get together 3 dayanim, and it's really a leap of faith, we're going to allow the dayanim to be in contact with each other through digital medium, and it's as if they heard the claims of the various Baalei Dinim. However, they add one stipulation, and that's called a signature on a shtar borus. Now we're entering into a whole new area of Choshei Mishpat called a shtar borus. For this, we need another half a year of work. A shtar borus means that the toveh and the nitbah could come to an agreement in which they allow the dayanim to come up with a non-halachic decision. What do I mean? They bind themselves by contract with 2 signatures to accept the ruling of the Beis Din, even if that ruling is not based on pure halacha. For example, the classic case would be mediation, and it means that the dayanim will mediate. They'll hear all the evidence one way or the other. They can't come to any definite conclusion, and they will come up with a kind of a compromise. Again, it's more complicated than just a compromise. It's not just let's split it down the middle. I mean, there are many, many halachic guidelines in Shulchan Aruch about borus, about how to set up this arbitration. So that even though we're relying on certain kinds of computer and digital methods of communication here in order to set up a Beis Din, but it's only a virtual Beis Din, so to speak. It's not a real Beis Din, and therefore we must get signatures of both Baalei Dinim on a shtar borus, which, by the way, is not an easy thing to do. Not everybody wants to sign a shtar borus and give so much power over to the Beis Din. Now we get to the issue of Eidus. Last week I mentioned to you there's an issue if the Eidim are wearing masks and we can't recognize them. Today I'm going to mention an issue that the Eidim can't show up personally in a Beis Din because they can't get out of the house. There's an epidemic. So what do? They send their Eidus virtually through the computer. And here we distinguish between 2 categories of Eidus. If the Eidus is just proof or evidence, then we're going to rely on digital communication. But if we need what's called Eidus le'kiyum hadavar, means when halacha requires the 2 Eidim be present in order to effectuate some sort of change in status, which is called the chalos, then digital Eidus is not Eidus. Now, there's another requirement in Choshei Mishpat, and of course,
sorry again. So the 2 witnesses, they're allowed to send which testimony? The If it's, what's the difference between them?
What I'm suggesting is here, based on, if you have page 3, that if there's edus that's necessary libirur hadavar, which means just to as evidence, tell us what happened. Did Ruvain borrow from Shimon and so forth? Then we can rely on digital testimony. Today it's so much more sophisticated. I mean, you like for example, you could see me, and there are all sorts of shilas as to whether or not if let's say someone on the Zoom screen would commit some sort of a violation, whether I could testify just based on what I saw on Zoom.
What would be the other case? I'm sorry. What would
but the other category is called edus l'kiyum hadavar. Sometimes a loan or some sort of monetary obligation has to be effectuated in the presence of witnesses. That's constructive. That's not just descriptive. That means in order to create a change in status, I need the Eidim to be there. Digital is not going to do it. So if Reuven wants to marry Leah, he can't do so unless there are 2 witnesses present. All the other methods of technology will not suffice. Now there's another halacha in a Jewish court, and that's called bifnei baldin, which means in the original biblical case is if I want to sue your ox, meaning you're the owner of an ox, then you have to show up in the Beis Din, and I have to testify against you if I'm a witness that you were negligent in protecting the ox. That's called lifnei baldin. And once again, we're going to have a question whether or not lifnei baldin is edus libirur hadavar or edus l'kiyum hadavar. In other words, would the technological and computer kinds of digital communication, would that be sufficient to substitute for lifnei baldin? So if I want to testify in a court of law against you, do you have to be there physically, or is it enough that you'll hear my testimony over the sound waves? Now, one thing is clear, and this is on the next page, page 4, that minui shlichus, I'll explain, does not require bifanov. I can appoint you as a shliach, as my agent, as my proxy, even if you're not there when I appoint you. I can appoint you over the computer, let's say over Skype or whatever it might be, right? And this is true even for a get. So imagine a man is stuck in Italy, and the restrictions are very, very tight, and he wants to give a get to his wife in Jerusalem. He can appoint the shliach to deliver the get. Normally, he gives the get over to the shliach. In this case, he cannot do so, but he can appoint the shliach over the waves, and that shlichus is legitimate. It's reliable, and now the shliach can come into the Beis Din in Yerushalayim and deliver the get. Okay. Now we should be up to page 4. This is the crux of the issue. Let's say, now I give you the easy case, and then we get to the more complicated variation. I order something that's only relevant to me during a certain period of time. And the case is matzah. I order matzah for Pesach. The seller could not deliver the matzah before Pesach because of Corona. In such a case, it matters not whether there was an explicit condition in the sale that spells out the fact that the goods have to be delivered by such a date. But here, we're going to we're going to apply the principle of umdana. Umdana means circumstantial evidence. No one is paying $100 for 5 broken matzahs, pardon the expression, because I always get cynical about this. It happens to me every Pesach. And delivered me the matzahs after Pesach. Broken matzahs after Pesach, even during Pesach, that's not worth $100. So that's called a mekach tos. That means that whatever monies I paid you, you have to reimburse me for, even though you're a muhsak, because it's absolutely clear and the evidence is obvious that I did not pay you to receive the matzahs after Pesach. Now, you're not going to believe this, but there is one posek who goes on record and he says the mocher does not have to reimburse the lokeh. Why is that so? Every sale stands or falls on what's called das kona. If there's no das kona, if there's a mekach tos, I didn't want to. Would I have bought these matzahs knowing that you're going to deliver them after Pesach? He says, and you'll see it here in footnote number Yud Beis on your 4th page, that there's another category here that has nothing to do with sales, and that's called Dina de Garmi. Dina de Garmi means if you cause me a loss in a very direct kind of way, you ordered the matzahs. As a result, I purchased the matzahs, baked the matzahs, whatever I did in order to deliver you the matzahs. You are now causing me a tremendous loss. Now, although there is such a posek who goes on record, unanimously, they rejected this psak, and I'll tell you why. Because even if I would grant you that when you ordered the matzahs and gave me money for the matzahs, and I went ahead and did whatever I did as a mocher to supply you with matzahs, I took a tremendous loss. There's one stipulation in Dina de Garbi, and that is you don't pay damages in a case of onus, in a case where you were totally guiltless and there was no element whatsoever of negligence. When I cancel my order for the matzahs and I want my money back, and now I'm causing you a loss, that's onus on my part. The fact that now there's a pandemic and I have no way of getting access to the matzahs, or for example, you have no way of delivering the matzahs, that's something that's beyond my control. And in the case of onus, there's no payment under Dina de Garmi. So, for example, halacha l'maisa, if the buyer says, I can't possibly get access, let's say there's a place where they're distributing the matzahs, I have no way of getting, transportation because I am in a situation where the government will not allow me, right? Here we have a lockdown situations, or again, you could have many, many different variations. In such a case, I have the right to get my money back. There's no din of muhsak here. Even if I paid you up front, you have to return the money. And therefore, on page number 5, if there was an iska, which means some sort of monetary agreement of a business deal, a transaction before the pandemic, and as a result of the magefa, there's no way that the monies could be delivered, is in such a case, the deal is off. Now, getting back to the catering case, if therefore I ordered catering and I have no way of showing up at this wedding hall to enjoy the food that you prepared and you're supplying, then I don't have to pay you for this order. Even though the order was done before the pandemic, and it was a perfectly binding commitment on my part, and I even gave you money up front, but now it becomes impossible for me to enjoy the benefit of the food that you prepared as a caterer. This is a reflection of another principle, which is called Meshicha in Metaltal, meaning that even though the Torah recognizes a kinyan of Mos, I'm going according to Rabbi Yochanan against Reish Lakish here, but anyway, nevertheless, the Rabbanon undermined the kinyan, and it's not binding until the goods are delivered. This is in the case of movable objects. And now, up until the moment that you deliver the catering to me, the kinyan is not valid. It's not binding. And therefore, I have a right to say, I don't want the kinyan. I'm out of here. And this is going to be an introduction to another topic here in Choshen Mishpot, which, again, it's up to you if you want to discuss this next week. And that is what happens in Schiras Karka. What happens if we have a rental agreement on a piece of real estate, on a house, or on the ulam? So it could very well be that in the case of a rental agreement, if I paid you up front for this ulam, and I'm renting this wedding hall, you have a right to hold on to that money. But as far as the catering is concerned, which is metaltalin, that money has to be returned because I never made a kinyan, I never made a meshicha on the catering. But he says the following: even if I don't have to pay the caterer for the actual value of the food, and that's even if I paid you up front, but what about the monies that the caterer has already spent out of pocket as a result of the order? Ha'otzaot shekvar hotzi ha'mocher yesh lo l'shalem. Fascinating. There's an entire discussion here in the footnotes in which he quotes a Bezdin, which is called Beit Din HaYashar V'Hatov. I'm not sure who the Rosh Bezdin is, but I think I once passed it. It's in Ramot, if I'm not mistaken. Well, let me check that out. And that Bezdin found a tshuva of the Rosh, which was virtually unknown, that if a person commissioned an artisan that he should prepare some sort of product, in other words, he should shape or fashion a product, and now the Uman went ahead and he prepared a beautiful sculpture or whatever it was, and the buyer says, I don't want to make a kinyan on it. This is not what I really want. Then although we cannot force the buyer to accept the agreement because he hasn't yet made a kinyan on it, but nevertheless, the Uman, the artisan, the manufacturer, could bill him for any monies that he paid out of pocket. And some of the poskim want to say that that's not true. That if I cancel the order for the catering, I don't even have to pay you any monies that you had outlaid because I'm an onus. I didn't do anything deliberate to cause you damages. We're suffering under the epidemic of COVID. And here's where the payment up front becomes the critical factor. Since we don't know, based on this debate amongst the poskim, whether or not the mocher, or as we saw in the case of the Uman, whether he at least has a right to get paid for any financial outlay, he may be stuck with the goods, go find another buyer, but at least as far as his loss of money out of pocket, he does have rights to get reimbursed. But the question is, does that apply in the case of onus or not? Here, if there were monies that were paid up front, then the mocher has a right to at least retain from the upfront payment the value that corresponds to his out-of-pocket losses. So, for example, if let's say the total price is 1,000, and the mocher spent already $100 with shipments and with different polim that he had to pay workers to get the food together and so forth and so on, he has to give back the $900 because the recipient says, I don't want your catering because I can't even pull off this wedding over here. I can't even get access to the wedding hall. But the $100 that was paid up front, the mocher could keep in order to offset his losses. And this leads us to page 6, which we don't have time for right now. And what I'd like to, in a sense, throw the ball into your court is to discuss next week these rental agreements, rental fees, or, for example, hiring workers, whether in these cases, if the rental agreement cannot supply the renter with any enjoyment, any pleasure, any benefit because of Corona, or, for example, the polim that I hired cannot work for me because so all the service they would have provided is lost. Do I have to pay in these cases? That would be a discussion for next week in the pages that I already gave you. And then we'll talk about not only hiring workers, but there's a specific discussion here in Israel about what's called gananot. I forget the English word for that. In other words, if you have a kindergarten and there are a bunch of ladies that are paid to take care of the children and they can't supply those services during this epidemic, whether or not they should be paid, salaries in general. Now I need to hear your input. Do you find this something that's meaningful? Again, we're not a bezdin. We're not going to come to any definite conclusion, but we can come up with guidelines. Okay, then. So we're going to stop here. I'll wish everyone a great week. And if anyone's interested, tomorrow night I give a shiur at 9 p.m. on Israel Clock on the insights of Rav Soloveitchik to the Parsha. On Friday, Amir Hashem, insights of Ramir Simcha Midvinsk, the Meshech Chochmah to the Parsha. And that's at 9:45 a.m. We changed the time on that, so note 9:45. And the other shiurim, for example, I give a shiur tonight at 8:30 in Masechta Yoma. All those shiurim go on Amir Hashem as usual. I'm thinking of a possible series to give, but that's still in the planning stage. Okay, then. Everyone should be well. Shenishma b'sorot tova.